Is this something that I really want to commit to? Is this something that I can protect? There's a whole business conversation that you could have about, can I get a patent on this invention? If you're getting a patent, you've basically created a new thing, right? A new device. You can get government protection to stop other people from using your patented invention for a certain amount of time. In the design patent side of things, which is
Jeff Holman, founder and CEO of Intellectual Strategies, helping startups and tech companies scale with confidence, bridging innovation and law so founders can focus on growth.
It's a whole new world. So there's a lot of things that act as impediments, act as unknowns. If I put tens of thousands of dollars into getting a patent, can I actually commercialize it?
Can you explain the difference between a patent and a trademark and why entrepreneurs should understand both?
So there's a lot of confusion oftentimes, and it's just because
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets.
Welcome back to Securing Your Brand with SecureMark Legal, where we break down the legal tools every entrepreneur needs to protect their business. I'm Holly, a trademark and copyright attorney.
And I'm Melissa Jeda, also a trademark attorney. Together, we help entrepreneurs build and protect their brands so their business can thrive.
Today, we're joined by Jeff Holman, who's an innovator, engineer, and experienced patent attorney. Jeff developed the patent roadmap for inventors and also talks about overcoming the 4 fears of every innovator.
We are excited because we're spending a lot of time on trademarks and branding, but patents are often the other half of that equation for protecting your brand. Jeff, thanks for joining us.
it's great to be here, Holly and Melissa. I'm really glad to be here.
All right, so let's start simple, Jeff. Can you explain the difference between a patent and a trademark and why entrepreneurs should understand both?
I'm sure you guys get a lot of people who come and they're like, hey, I've got this new business. I want to trademark my invention. I want to patent my brand and stuff. A lot of confusion oftentimes. It's just because there's just different layers of IP, and it's really, it's not something that's inherently understandable, I think, to a lot of people who are just launching businesses. So it's a great question. I kind of look at, because you guys mentioned trademarks and copyrights that you do a lot of patent stuff. And so I kind of look at the areas of IP and I say, well, there's some areas that are for what you create. And that's really the patents and the copyrights. Those are the things you're creating, and you want to protect the inventions and the works of authorship, which you guys could go into great detail on for copyright stuff. But then the other side of it, just to contrast that, is the things that how you use some of your assets. So trademarks, trade secrets, trade dress, that's how you use the things and the ways to protect that you're using them as opposed to what you're creating. So patents are that one bucket. I've created an invention. The invention might be a new device, a new piece of hardware, a piece of software. It might be, and that's all on the utility side of things, not to get too far into the layers. There's also design patents that protect kind of the look and feel of something. But patents really are about what you've invented, the thing, and how it works for the most part. For the majority of people that are out there looking to say, hey, I've invented something and I want to get protection for it.
Yeah, we always say that trademarks protect what makes your brand recognizable. And a patent protects how something works, how that product was innovated. What is the timeline difference and how do those differ?
They differ in a couple ways. In the patent world, there's a lot of layers here, and I always try to break it down for people from the beginning. So if you're getting a patent, you've basically created a new thing, right? A new device. So it might be a product that you want to sell online. It might be a piece of hardware that goes into a computer. It might be, anything that you've created that didn't exist before. And so the government gives you a monopoly, essentially. They say, hey, if you will disclose this patent and tell other people how to make and use it, you can get government protection to stop other people from using your patented invention for a certain amount of time. It's a limited time, though. And a utility patent world, again, the things that have kind of structural, functional uniqueness to them, it's around 20 years. In the design patent side of things, which is more about the unique style, the way something looks, as opposed to how it is built or how it functions, that 15-year period. So you only get a certain amount of time for protection. Whereas, of course, for trademarks, that's, I think, one of the best assets you can get. That can go on for, indefinitely, as long as you're using that in the right way. So some differences in strength and some differences in duration of how long those last.
And for listeners who are brand new, what are the main types of patents that entrepreneurs should know about? And which do they most commonly need?
I'm going to break this down into a couple layers because maybe like 3 levels that we have to talk about this. And I'll go through it quickly, but the ones that your audience probably needs to remember. So in general, there are 3 types of patents in the US. This is broadly, country by country. Every country has kind of the same regime, but a little different. But there's three types of patents. We've mentioned utility for something that's kind of a new thing, a new mouse, a new phone, a new hardware, something that you've invented. And then there's design patents. That's how something looks. And those are the two most common. And then there's something else that's really rare out there called plant patents for asexually reproduced plants. If you go into a room of patent attorneys, ask if anybody's ever done that, probably nobody will raise their hand. Maybe one person out of hundreds will raise their hand. I've seen it a little bit. I've worked on it once with one company, and that's it. The rest of my career, hundreds or thousands of inventors have all been utility and design patents. So that's the first layer, right? Those are the three type of patents you can get. Now, within the utility world, which is where a lot of people, inventing a new product will start, and that they'll spend most of their time patents. There's two layers there. One is what we call a non-provisional patent application. So a non-provisional is that's the formal application that you have to file with the patent office, get it through the process in order to have a patent and, enforce that patent against other people. There's another application type that your audience should be aware of. And this is one where small inventors, solo inventors, people who are just getting started often will start with what's called a provisional patent application. The provisional patent application is just a more basic version of an application, and it's really only a placeholder. So it sits, you file the application, it goes to the patent office. They never examine it like they would with a non-provisional. They just let it sit there and they say, hey, it's going to be here for 12 months. It's going to hold your place in line. And if you decide to file the non-provisional, then we can link these together and you can get credit or priority for the time that you filed your provisional before you actually filed the full, formal, more complete application down the road. So that's the second layer, right? When we get into utility patents, there's often a need to know about provisional patent applications versus the full non-provisional process. And just to round this out, so that people can go back and listen to this if they want to, and maybe hear it again. The last layer I will add is every country has their own patent system. So while I'm talking about patents in the United States, if you wanted to get a patent in Japan or Australia or China or Europe, somewhere else, you have to go into individual countries and get a patent in each country that you want protection. Now, there are ways to link patents together through international treaties, international agreements, things like that. So you'll hear people talk about something like a PCT patent application or an international patent application, or maybe the Paris Convention. Those are all just ways to link applications together between countries. So I wish it was a simpler overview, but those are the three layers that I would say. What do you do in the US? What are the two types that really people deal with when they're looking at utility patent applications? And then be aware that you have to coordinate among countries if you want to get protection, around the world.
And we often talk about that with like a trademark application, about how you can have trademarks in multiple countries and how how they can be linked together and you can get international trademarks. That's like the application of it and the application, of applying for your patent. But before you apply for the patent, there's a lot of steps that you have to do in the process before you could apply for it.
So this is where people often get a little overwhelmed, right? I think that in fact, I talk sometimes about, this is not a patent issue, but I talk about the 4 fears of innovators because, like you mentioned, when people are coming into this world, if they haven't done this before, it's pretty overwhelming. I mean, people might, after just listening to me explain the different layers of patents that I did, they might be like, oh man, that that sounds a little difficult. And it's just a foreign world. It's a different world for people. And so they come in, they've never invented something. They've never manufactured something. They've never, priced something out. It's a whole new world. So there's a lot of things that kind of act as impediments, act as unknowns. And we can get to the 4 fears later if you want to, but this whole business side of patents, I could talk all day long about the laws and rules and processes and examination steps. And we could get into that if you like. But there is a business side where a lot of people should be saying to themselves, is this something that I really want to commit to? Is this something that I can protect? Is this something that if I put tens of thousands of dollars into getting a patent, can I actually commercialize it? Can I make it in a way that is affordable and that actually does what I think it's going to do? Can I sell it for a price point that will make it worthwhile? Can I distribute it out to the buyers? Amazon, of course, has made that relatively easy for a lot of people in the consumer goods space. But there's a whole business conversation that you could have leading up to this and that really evaluates, is this a good business decision in addition to the conversation about, can I get a patent on this invention?
Speaking of Amazon, so if we have a small entrepreneur that's just come up with, some invention that they want to sell on Amazon, how do you generally advise as far as international patents? Is it necessary to go around and get a patent in all over the world because Amazon sells all over the world? How do you
That's
kind of keep rein that in? 'Cause that
yeah,
sounds
that's
overwhelming.
that's a great question. And let me tell a story about what not to do first. I had somebody come to me and they were inventing. I've had maybe 2 clients actually in the past who kind of insisted on, hey, this is going to be a global invention. These actually weren't these were in kind of the energy space, I'll call it, right? People were doing stuff with like oil field cleanup and with converting plastics into biofuels. And so they were doing some stuff like that, right? They're not even in the consumer space, but they came and they said, hey, this is going to be everywhere. I want to patent it in 25 countries. And I'm like, no, you absolutely do not want to patent it in 25 countries. It is going to be astronomically expensive to patent it everywhere, right? They did proceed with paying to patent it across way more countries than I would have suggested. So let's pare that back, because most people don't have that budget. Even
Right.
people
Most
like
people are,
IBM.
most
Sorry.
people are smaller entrepreneurs. They're just inventing something for the first time. Right.
Yeah. And while there's excitement around it, you don't want to get kind of dragged into the excitement and blow your budgets. I mean, in the end, people we're talking about right now, they typically need to reserve a lot of budget for validating their invention and the marketability and making the product, and not spending it all on legal, right? We're supporting the business, not the main part of the business.
Mhm.
So even companies like IBM who have global, they don't patent everywhere. They pick a couple strategic places. Here's how I would advise a client who's in the Amazon space. You want to look at where your market is that you're selling, and that's probably where you want to put most of your attention. For almost all the people that I've worked with, that's the US, right? Even if they're coming from Australia, New Zealand, Europe, somewhere else, they say, hey, I'm going to try to sell in the US, so I want to get a patent in the US first. So that's the number one. Number two, where are you making your product? A lot of people are making their product overseas, relative to the US. So you probably want to consider whether or not to get patent protection in somewhere like China. And a lot of people have, if you listen to like the kind of the historical conversations that say, oh, you can't protect your patents in China. That's actually not true anymore. It's much easier. I mean, enforcing a patent is a lot of work anywhere. But it used to be that enforcing a patent in China was kind of not even an option. And now it is. It's just expensive, right? So where are you making your patent, or where are you making your product? That's the other place. And those are the two where I would say, hey, focus on those two first. If you can cover those two, you've covered 90% of what your business really is. If in some circumstances, you might also want to look at where you're shipping your products, how you get your products from the manufacturer to the ultimate market that you're selling into. And so there are some ways, and similar with trademarks, right, where you can actually use customs in different places, ports perhaps, and you can register your patent, and you can have customs actually help you enforce to a degree your patent rights. And so if you're shipping through major ports, or your product is transporting through a certain place, you might want to look at getting a patent in that location. So we've got, where are you selling it? Where are you making it? How are you transporting it between those places? And then the last one would be, where are your competitors? You might want to just say, hey, I'm in the US, I make product in China, I sell it in the US and Europe, but my primary competitor is in Japan. So maybe I'm going to add Japan to my list. I want to get a patent in Japan just so my competitor can't practice my invention, somewhere that I don't have a patent. Super comprehensive, strategy to file in all those places. It'd be expensive. And so those are the places where you would think about filing. Normally a new inventor with a new business without a lot of funding behind them isn't going to file in all those places. They're going to file, in one place to begin with. And that's going back to how we can connect the patents together across countries, and the provisional and non-provisional process can be connected. That's really where the power of these layers and these connections come into play, because you might say, well, I'm starting out, I'm still testing the market. I'm going to file my provisional patent application now. That gives me a year before I have to make any bigger decisions. I'm going to go test the market, see if I can make my product. In that year, you maybe you find that this is something worthwhile you want to pursue. So then you file your non-provisional in the US. And you can also file that international PCT that we talked about. That'll reserve your rights to file in other countries within the next 18 months. So you kind of have these stages where, hey, start small, take maybe a little bit more of a bite size than file everywhere all at once for $50,000 or $100,000. Spend that $5,000 first, then work on your business, then spend something more, then work on your business. Then, eventually 3 or 4 or 5 years down the road, you might have patents in all those different places I talked about.
And also, if potentially there is a question of patentability for you're wondering, is it unique enough? Am I going to get a patent? Would you maybe start in one place as a strategy there, maybe to make sure you can get it in the United States before you apply anywhere else?
Because ultimately what you're getting at is you have to have examination of your patent application in any country that you want protection. Now, some countries will look at other countries and say, well, we see what they did. We're going to kind of just follow the same route. And if it was successful, then you're probably going to be successful. That doesn't happen everywhere. It happens in a few places. So every country, you have to eventually have to get into each country you want protection, and you have to go through their standard examination process. To your question, doing that and maybe accelerating that process in the US might give you a better indication of how other countries will treat that examination in those countries later on too. So that's one way you can do it, is kind of stagger which countries you move faster in and which ones you move slower in. This is one of the main questions we get with inventors is, hey, I want to know if this is patentable before I even file an application. What kind of searching can you do for me to tell me that this is, to ensure that I'm going to get a patent when I spend $10,000 or whatever to file this? And patent searching is fantastic. It's kind of a double-edged sword. The bottom line is this: if you can afford to do patent searching, you should totally do it. The other bottom line is this: most people can't afford to do the type of patent searching that really should be done and file for their patent application and go off and figure out how to manufacture it and make it and sell it. Like, resources are just constrained. So you have to balance out how much time and effort do I want to spend looking for something in a patent search versus just getting patent pending status from the get-go. And I say that because patent searching, maybe a little bit more so, maybe a lot more so than trademark searching, patent searching is a big black hole. You are trying to prove that something doesn't exist in a vast, we call it a database. In the world, you're trying to say, well, that doesn't exist. It'd be like saying, well, there are no plants with green and orange and purple berries on them all at the same time. I mean, prove to me that nowhere in the world does that plant exist. You would have to look at every corner of the world and eliminate, by the process of elimination, say, no, we never found it, so it must not exist. You can't prove it doesn't exist, right?
Yeah, that whole proving a negative thing, that's always...
Exactly. So just to give some context for this, when we have a client who's really serious about patent searching, and this won't be your audience necessarily. When somebody comes and says, if a big company comes and says, we're launching a product, they might spend $100,000 just doing that searching and analysis to see if they're going to run into any problems in the process, right? Can they get a patent? Are they going to infringe somebody else's patents? And there's a huge, and those are kind of two sides of the same coin, but there's going to be a huge assessment that they do. That's not practical for most small solo inventors. And so what we find is, if we do some searching, they usually want to do, hey, let's just spend a couple hours, see what you can find. If you don't find anything in a few hours, let's then move on to filing the provisional patent application. That will get me patent pending status, which is super important because that then kind of opens the door to let you go out and talk more freely about your patent, about your invention. Because if you don't have patent pending status and this is a whole different topic. If you don't have patent pending status and you're talking about your invention, you've now done something called a public disclosure. And unlike trademarks, where it's actually good, I think, maybe you guys have opinion on this. I think it's great for people to get out there and use their trademark. I'd file first if I could, but if you can't, go use it and build up some of that brand equity before you file. In the patent world, it's the opposite. If you disclose your invention before you get patent pending status, then in most circumstances, with a couple exceptions, you actually just did the thing that's going to prevent you from getting a patent later on, because the whole government system is set up to incentivize disclosure. If you will disclose this, we'll give you patent protection, assuming that you meet all the criteria. If you've already disclosed it, there's no incentive left to give you patent protection. And so they say, well, it's already public knowledge. We're not going to give you, the ability to stop somebody else from doing it if they already know about it, right? So you have to really think about the timing of when you do that, when you talk about your invention versus when you get patent pending status.
Yes.
So maybe a big difference from trademarks.
It is a very big difference. Yeah, because in trademarks, we have common law rights, right? We talk to people about that all the time. If you've been using this name forever, but you haven't filed for a trademark, you still have rights. We still need to know how far back that goes and where you used it and things, and that's a positive. But yeah, that's interesting. With patents, it's the opposite.
None of that common law being, of course, the courts say, hey, you've been doing this, and we recognize that it's only fair for you to have some rights in this. Trademarks, that exists. Patents, it's all statute based. It's all laws. There's no like court made laws around it, really. And so if you don't file, you just then you don't get it. Now in the US, there is an exception called a 12-month grace period for inventors who disclose their invention before filing. If you then go and file within 12 months, you can essentially take advantage of that grace period and still get, still not bar yourself from getting a patent. The downside is if you wanted to file in any of those other countries, like where you're manufacturing or where your competitors are, they probably almost all of them will say, no, sorry, we don't have a grace period. We have what's called an absolute bar. If you already disclosed it yesterday, you can't get protection by filing today. It's that black and white.
You've already filed a U.S. application, or if you've just had public disclosure without a U.S. application?
Sorry, what was your question about?
If that is that for international filing? Is that if you have a U.S. application, you can't file there, or if you've disclosed it before you filed your U.S. application?
Okay, great question. So it's based on the disclosure, right? If you file in the U.S. and you follow the procedures to link your other applications together in other countries, as long as that filing and linking happens properly, you're totally fine. But if you disclose before you file anywhere, or we have some scenarios where people disclose, they'll be like, well, I disclosed my invention, but I still want to get a patent, so I'm going to file in the US. And then later on, they're like, well, I really want to get a patent in, Japan or Australia or one of these countries. And we say, well, we have to go look now because you filed under the 12-month grace period in the US. But we have to make sure that the other countries you want to file into allow that. And if they don't, we can't make that link to the other countries. So it really takes a bit of analysis to figure out if you don't file before you disclose, down the road, you're going to run into road bumps and some obstacles and some places that you won't be able to get protection. So we always encourage, whenever possible, we know a lot of inventors come to us. They've been excited. They've posted this on Facebook. They've gone to a trade show. They've, made a prototype and shared it with their friends. And then they're like, hey, somebody said, I didn't know, but somebody said I should come get a patent. So I'm here now. It was innocent, but they've disclosed their invention, and those roadblocks are going to exist. So that's just part of the reality of it. And we encourage people, as soon as we are involved, say, hey, let's talk about public disclosure. Let's talk about these things that will create bar events or obstacles for you getting patent protection either in the US or in other countries, and try to minimize those so that we can preserve the optionality that the inventors will have going down the road.
That makes timing a huge issue, and that makes timing a huge consideration, where in the trademark world and the copyright world, because there could be some issues for timing and copyrights, we always talk about in trademarks, you can never be too soon, but you could be too late. But in this case, you really could be too late and not entitled to that protection.
And it's black and white. It's pretty harsh. In fact, we have people who say, there's kind of this, so not to be confused with the 12-month grace period that you can disclose and then file in the US. For linking these applications together, whether it's under what's called the Patent Cooperation Treaty, or under the Paris Convention, just different versions of countries saying, hey, let's work together so that people can file patents across borders. That also has a 12-month period. So when you file your first patent application, you have 12 months to file in those other organizations or jurisdictions and make those links. And if you don't do it, then again, you lose the right to do it later. And so we'll have people that will talk to them and we'll say, hey, you've got your patent application filed, your provisional patent application, perhaps you're, going out there exploring manufacturing, you're talking to people about maybe selling this or trying to get it onto Amazon. And that year from when you first patent to when you have a deadline to link other applications to it, if you want to get into other countries, moves so fast. And a lot of people come back and they're like, hey, Jeff, I haven't made as much progress trying to make and sell this. So I don't know what to do. And I'm like, well, if you haven't made a lot of progress in the last 12 months, I mean, that's reasonable. It gets really expensive really fast to file in other countries. Just take the numbers in the US and multiply them for other places. I'm just going to focus on the US. I'm not going to file. And then say 6 months later, they come back and they're like, oh, I had this awesome thing. I got my product. It's being manufactured, overseas. And I got this big retailer who wants to sell it and they want to go take it and sell it in Canada. And I'm like, that's awesome. Remember, we can't protect this in Canada though, or we can't protect this in the other country because we didn't file by that deadline, right? You can't go back and reverse engineer that. These deadlines are really harsh. And at 12 months at the beginning sounds like plenty of time, but it moves so fast when you got a normal job, you got a family, and you're trying to build this side hustle around some invention that you came up with that you've never done before. And so you just have to, the timing is so critical in the patent world. I couldn't overstress that for your audience. Timing is going to drive so many of your decisions in the process with patents.
Yeah, it's really, especially for startups and inventors and things along those lines, it seems like, they want to get it out there. They want to get to market. They want to make sure it's viable. That invention is something that people want, but that has that, okay, we've got public disclosure consideration to take and, to consider. And so it really does become an issue of what do we do first? What do we prioritize first? Do we prioritize making sure we can get a patent first and then making sure we can own the name at the same time when we're still trying to invent, and go through those process for our entrepreneurs? And I think from what you've taught me today, I really think it's make sure that you can patent this, make sure that you start your provisional patent and save your space in line, kind of your first to right in line. Make sure that the name that you want to sell this product under is available, because that's not disclosure. Just doing the search and filing the application, is that going to be a disclosure issue, even if you haven't talked about what the product is yet?
Like filing a trademark application with a description of goods and services, you wouldn't be disclosing the details of the invention in that process. So if you can save your place in line with patents and trademark, in fact, I look at it this way. I kind of talk about these three things, right? You got to validate that your technology works, number one. And you mentioned validation. I think I'm going to split it into two pieces. Validate that your technology works, that you can make the product the way that you want to make it and will operate the way you want to operate, right? That's in the invention world, that's not always possible. Some people are like, I got this idea, but you can't actually do it. So you have to validate that you can make the technology or the product. Then you want to validate that the market exists. That means, can you make the product at the right price and sell it at the right price to make, the right margin that you can actually have a business. So validate the technology, validate the market. And then the third category is what you and I do, what I call freedom to operate, right? We want to be there to make sure that if you have a product that you validated and a market that you validated, that you then have freedom to operate your business. And freedom means I can go out and I can make my product without somebody else telling me I'm infringing their product. I can go out and brand my product and sell my product under a certain brand without infringing somebody else's. I can protect my patent, my invention with a patent. I can protect my brand with a trademark, and I can stop other people from doing that. I can put the financial bases in place so that I can actually run a business. Like I can put my entity together and I can protect my potential liability, product liability, things like that. So that all falls into the less sexy category of freedom to operate, which is a lot of financial, regulatory, and legal issues that aren't necessarily as, don't get the spotlight as much as I'm going to make a new product and I'm going to sell it into this target market.
And that really comes through as in a trademark world, you've got the value of protecting the foundation of your business, protecting your brand, your reputation, but a patent really protects that invention and going forward. That also adds value to your business.
I think early on, people tend to give more weight, like investors and maybe just, friends and family, like, oh, you got a patent. That's so awesome. And they might give more weight to that. I don't know if that's right or wrong, but I think long term, the real value for most businesses is going to be the trademark assets, because you've built a brand, you've built a brand following, and they're tied to that trademark and the goodwill in that mark. And so I think that this is where we, again, talk about layer. I mentioned layers of patents. There's also just these layers of IP. And you want to think about, how do I put all the right layers in place over time so that, I have that initial value and I can get people excited about buying my product and maybe manufacturing my product because I've got exclusivity and I can stop other people. I can license it out. But long term, the goal is to build that brand and to have the enterprise value, which might come back on the patent. A lot of people are like, oh, my patent's worth $10 million. No, it's probably not. It might not be worth anything, actually, if you do it wrong. But your brand, if you have a company with a brand following, your brand is going to be one of your best assets in your business. In fact, there's a study out there. It doesn't necessarily apply the same way to really small businesses as the study suggests, but the study says, out of I can't remember the exact details. It's like S&P 500 companies, the largest companies out there, attributing 85% of their overall value of their business to their intellectual property. And that's going to be their patents and copyrights and trademarks and things, their trade secrets, things like that. 85%. And then we're talking billion-dollar companies. So hundreds of millions of dollars out of $1 billion is all based on the fact that these guys have developed and protected their IP. Again,
and that IP portfolio is huge. That IP portfolio creates the value for your business, for lenders, for investors, for selling it, for franchising it, for licensing it. All of that IP portfolio built together, and having a complete portfolio is important to allowing a business to grow.
Oh, for sure. And even though it's different for smaller companies, I think it's still very significant, because I see, you and I, we see people go out and they're like, hey, I started this SaaS platform and I've got so many users. Well, you're building your brand base. They're following your brand. And so that's really tied to the branding of your platform, in addition to the functionality, of course. And other people, they're like, hey, I invented this new product and I went out and raised $1 million based on an idea. I filed a patent application and I found people and they want to fund it. And it's not one-to-one with that big study, but you can see early on that investors and partners will give a lot of weight to whether or not you're really protecting your freedom to operate your business, like I mentioned before.
So a lot of our audience are entrepreneurs who might not see themselves as inventors. From your perspective, what are some missed opportunities, things patents can protect that they may not even consider?
It's a fantastic question, because this is where I think design patents come into play. And let me say this up front. Not everybody needs to have a patent, right? Not every business is going to be a business that is going to apply for patents, because you're just not inventing things, right? A lot of service-based businesses, they don't invent new things. You provide marketing agency services or PR services, or a lot of law firms don't have patents because they're not inventing stuff, right?
Right.
So not every business needs to have it, but when you can have it, it can be a really good asset for your business. The place that everybody goes is they're like, I invented this thing, right? This new product. And so that's really tied to the utility applications that we talked about, new structures, new functions, which I know sounds a little engineering, perhaps the best way I know how to describe it. The other side of that's kind of surprising to people sometimes is they're like, well, I went out and I bought this product. I went to, in fact, I've got a client who helps some of my other clients go out to China and manufacture products, right? And so I went with them to the Canton Fair. The Canton Fair is like the world's largest product fair. It goes on for 3 weeks, twice a year, I think, in Guangzhou, China. And you go out there and there's like assembly halls, A, B, C, and D. These are like airport terminals full of booths of products. I was there during 1 week. It was like housewares, glasswares, furniture and something else. I didn't even get to see the electronics week or the baby toy, baby products and toys week. Like, it's extensive, right? And so people will go out there, and not everybody's going out there saying, I'm going to invent a brand new product that never existed before, and I'm going to create awareness, and I'm going to, teach people that it exists. And that's a lot of work to tell somebody to buy something that never existed before. So they'll go out there and they'll say, well, I want to find a product that I can take. I can adapt it a little bit, make it a little unique. Maybe it's not a whole different product, but I can put my stamp on it, right? And then I can sell it as my product. Well, that stamp, that you might be thinking, I'm going to put a little, something on it that's more design style than it is structure and function. I'm not changing the material inventing a new different type of metal that the thing is made out of, or I'm not creating new electronics inside of it. But when I get it, I might want to put kind of like a logo on it. Think of it as a logo. And you've probably heard of, this is not the Apple, but there was that whole debate about the rounded corners on the phone. That was design patent stuff. And it gets really nuanced. But if you just think of design patents as protecting an ornamental design or an ornamental style of something that's unique from other things, you can actually get a design patent. It's cheaper and easier to get typically, and easier to enforce typically than a utility patent. So that's kind of a surprising area where people say, oh, well, maybe I don't have to invent a whole new product. Maybe I just need to take a product that I can source somewhere, add my design to it, and sell it with some patent protection. And design patents, just for reference, show up in a lot of places like apparel or shoes. You see a lot of companies adding design patents to their shoes, because all the little elements on there, not only could they be trade dress or trademark, they could also potentially be design patent. Mm-hmm. And there's the possibility for some overlap or some crossover in those different layers of IP. So that's one area that I would tell people to look at.
Can you think of any maybe famous design patents that people would know just from everyday products or things that we see? Yeah, just for some examples for the audience. Yeah,
I don't have one off the top of my head. That's a great question. I should have some examples. But if you look at, do you guys remember? I'm going to assume you will. But when I was growing up, all of the headlights were standard size, standard shape headlights on cars, right? You needed a new headlight, you bought the same headlight, whether you were driving a fast car, or a slow car, or a big car, or a small car. At one point, I think it was in the 90s, all these cars, I don't know if like the Department of Transportation in the US changed their rules and said, hey, you can design these different parts, or if just the car manufacturing industry as a whole said, hey, why are we doing all these round and rectangular lights and nothing else? Like, we can make some really cool lights. And so car manufacturers started building cars with all these elements to them, these design elements. And so you see cars now, sometimes a manufacturer will take a design element and they'll carry it throughout their models of cars. Like maybe the headlights have a certain look to them, or the tail light across the back has a certain look. And so those are types of things that car manufacturers will get design patents on. Other things, like I mentioned before, shoes, if you look at, and man, I'll bet you money, I think I've heard this, and I probably should have researched this to confirm it before I say it, but I'm going to show some ignorance here too in the fashion world. Which are the shoes, the fancy with the red sole? Right.
I love that Holly knew you were going right there.
You knew it. If that's not a design patent, I'll be shocked. Right. It's probably got trade dress aspects to it too, which is different but similar. But if that's not a design patent, I'd be shocked, right?
So it doesn't change the functionality. The headlight's still a headlight. The shoe is still a shoe. It is what makes that unique, which is part of what we say is trademarkable. Like you said, it's part of the trade dress. It's part of the trademark. You could trademark that red bottom of that shoe. You could probably trademark the design shape of that headlight. And in that regard, it's not changing the functionality. It's still a headlight, but it's changing how that looks and appears to the consumer.
Functionality versus the style or design, right? That's a really important distinction in trademarks and in design patents. But there is that crossover because trademarks are protecting it from a branding perspective, whereas design patents are protecting it from an invention perspective. And so you might invent something and protect it and not use it for branding. But if you decide to use it for branding, then you could also layer on top of it the trademark protection too. And so that's where this overlap can happen.
It extends out that portfolio, extends out that protection where a design patent or utility patent has a limited time period. That branding is going to extend that out beyond the patentability time period.
Yeah, that's the major downfall to patents are really strong, but they do not have a very long life relative to trademarks and some other things. And so being able to get the trademark protection in addition to patent protection is an awesome combination in my mind.
I can also see this apply to like packaging too. How that box opens, how that envelope or how that container opens. That could also be a combination between trade dress and patent or design patents.
I love that because you could in a packaging scenario, you could actually incorporate trade dress, design patents, and potentially utility patents, because not only does that box have a certain ornamental look that is unique and you're using it for branding purposes. So you've got design patents and trademarks. The way that it actually unfolds or is folded together and created or glued, that the structure underlying the movement of it or the look of it could also be a utility patent. So you could essentially layer multiple different types of things together to protect that. Now, to put all that money into one type of packaging for a small company is probably overkill, right? It's probably going to blow your budget. You don't have money for it anyways. But when you get into an area where you're selling, millions of dollars of one type of product, and that's your major SKU or your major product line that you sell, you're going to really think differently about layering these IP, these types of intellectual property together to protect that in a different way than if you're like, hey, I'm just going to take a swing and see if I can sell this thing and, see what happens. So at different stages of your business, IP is you're going to use it in different ways.
Do design patents have the same disclosure 12-month timeline like utility patents do?
Yes, they do. A couple other distinctions. I mentioned before that design patents expire a little bit sooner, about 15 years instead of 20. There's some really interesting things that come about. You can use non-provisional utility applications as a priority in some instances for a design patent, but you can't necessarily use a design patent as priority for a utility patent. And you can't use a provisional as a priority for a design patent. So there's some ways that these can link one way, but not the other way, because of how they work. And so we get a lot of people up front who bring us a new consumer product. They're like, I'm going to launch this product and it does these, I'm making it different and it has this cool functionality. That's all utility patent stuff. And I'm going to add these, I'm going to make it cool so people, they look at it and they recognize it. That's design patent and trademark. And we say, okay, just so you know, your options are to file a utility patent, either the full utility or the provisional. If you do the provisional, you might want to consider doing the design patent too, because you can't link a provisional and design together. And oftentimes this is one of the most common things we see. And I wouldn't call it a mistake. It's just, it's a function of budget mostly. People will say, well, I only have enough budget to do the provisional right now. I'm not worried about the design. And then they get down the road and they manufacture their product. And they're like, people love my design. I want to get my design patent. I want to file now. And we're like, well, you started selling your thing already. And, depending on the timing, you may or may not be able to file at that point. So again, timing is just, it's maybe the biggest obstacle that we have in the patent world is just getting the right timing down.
Okay. What's the biggest misconception about patents that you wish you could clear up once and for all?
There's some truth to it, but there's also a lot of mistruth to it. And that is, you hear a lot of people out there who hate patents and they say, if you can't spend $1 million to protect your patent from attack, then you should never even file for patent protection. And while it is true that it's very expensive to enforce your patent against somebody else or to defend it if it does get attacked by somebody else, there are hundreds of ways to use your patent or your patent application even before it's even granted, to leverage that into your business that doesn't require you to have a war chest of $1 million sitting ready to go. So that's one that if you hear that, just know that it can be very expensive, but you're probably, if you're smart, you're going to leverage this patent asset many times over in a lot of different ways. And the $1 million question might never even come up. If it does, it's going to be a big issue. But if it doesn't, if you've avoided filing for any patent protection because of this fear that maybe one day you won't be able to spend $1 million to protect your patent, I don't know. That's like saying I'm not going to ever buy a car because one day it might get, it might get in a wreck. I don't know. If you buy a car and you never wreck it, you will have gotten a ton of value out of it. I wouldn't let the concept of a potential wreck keep me from buying and using the car, all the time. Now, if I buy it and I get in a wreck the next day, that's really unfortunate. And some people run into really big obstacles really quickly in the patent process. You hear about some large companies, maybe size of Google or Apple, or people accused of ripping off small inventors' ideas. And I'm not here to say it does or doesn't happen. The likelihood of it happening to you is pretty low. So just like the likelihood of you driving off the lot and, dying in a car accident that day is also, I think, pretty low. Where I live, I don't know, maybe somewhere else it's higher.
We hear the fear that it's too expensive very often, or that if I can't protect it, I might as well not do it. And I agree with you. It's really more about timing. You're looking at your timing, you're making all of those considerations into how I need to protect my brand in the future, grow this, start with a solid foundation and move forward. Jeff, this has been absolutely amazing. This has been super helpful. I have learned a ton of stuff. If we're going to talk to our entrepreneurs and we're going to give them one piece of advice about protecting their invention, where they start, what they do, where they consideration, what is this? What is your final tip here?
Most people in that situation are going to start with a provisional patent application. It's just the cheapest, easiest, least difficult way to do it, assuming that it applies to what they're doing. It's probably going to cover 80% of the cases out there. That's just going to be the starting point. Provisional patent application is just save your place in line again, get your 12 months of priority period in place so that you can go out and you can do those other things, validate your technology, validate your market, and make a bigger decision later. But that's going to be the starting point in the patent world for probably 80% of the people you talk to.
Okay. And where can listeners find out more about your work?
I'm on LinkedIn. People can connect with me there. I'm also got my website, and I do a free 30-minute strategy call with people. So if people are thinking this is something they might want to look into, just go to intellectualstrategies.com. You can pull up my calendar. You can book a call with me. I mean, there's a lot of information here, and so it's hard to get through. What I should do is I should say, hey, if you've got patent questions, you should probably listen to the SecureMark podcast episode first, so that you can really spend those 30 minutes with me doing more stuff. But I'm happy to walk through all of this with people, and I do it on a regular basis because it's a hard thing to learn, and it's one of many hard things people are dealing with when they're just starting out on this path. So I try to make myself available to help, not just do the service and get paid for it, but to just educate people along the way.
Thank you so much for joining us. It has definitely been educational for me. I have learned a lot from this episode. And really, I've learned more about timing than, we've considered before in the past, about advising our clients about the timing of it. And it's a good idea to speak with a patent attorney when you're first starting out. Get the lay of the land, understand what it is that you need to protect your brand and your innovation moving forward.
And thanks to our listeners, make sure you subscribe so you don't miss our next episode on building and protecting your business brand.
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets. While we are lawyers, we are not your lawyers. So nothing contained in this podcast creates an attorney-client relationship or constitutes legal advice. The views and opinions of guests on our show are not necessarily those of SecureMark Legal and are provided for informational and educational purposes only. This presentation is protected by U.S. and international copyright laws. Reproduction and distribution of the presentation in whole or in part without written permission of SecureMark Legal is prohibited.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.